Started and let the chairman come in. Hopefully, we can always swear him in when he gets here. And so the Subcommittee on Government Operations will come to order, and without objection, the chair is authorized to declare a recess at any time. It is the chairman's responsibility under the rules of the House to maintain order and preserve decorum in the committee room. Members of the audience are reminded that disruption of a congressional business is a violation of the law. We certainly welcome your presence, and we would just caution you against any disruption. Good afternoon and welcome. Today's hearing will shine a light on what Congress intended when it passed the Home Rule Act in 1973. We're not here to discuss the soundness of the district having a budget authority as a policy matter. Our goal today is to determine whether the Local Budget Autonomy Act was consistent with the Home Rule Act enacted by Congress. In addition, today's hearing will seek to identify the potential ramifications that we may face by the District of Columbia and local D.C. government employees in the event the Local Budget Autonomy Act is enforced. And at the outset of our country, the Founding Fathers saw fit to vest in Congress the constitutional right to maintain supreme legislative authority over the district. So it is important, so important was this, that the authority to James Madison, that he even took time to expand upon the necessity of the federal government having an independent seat in the Federalist number 43. It was a result of this indispensable necessity, as Madison described it, for an independent seat of government that the District of Columbia was created. And in 1973, Congress undertook the process of delegating to the district a limited home rule for the first time in roughly 100 years. And it did so undoubtedly with the need to maintain its constitutionally vested authority in mind. The voluminous congressional record associated with the Home Rule Act serves to demonstrate the need to balance popular sovereignty for the people of the district against the essential requirement that Congress maintain its supreme legislative authority. Reviewing the record shows that numerous debates, hearings, and discussions were had over many of the provisions in the final Home Rule Act. In fact, the debates and editing continued all the way through to the House floor, where very important clarifying changes were made that were incorporated in the final version of the Act. During the floor debate, a number of edits were made which, in the words of one of the principal architects of the Home Rule Act, Chairman Charles Cole Diggs, Jr., clarified the intent of the Act. I ask unanimous consent that the Chairman Charles Cole Diggs, Jr.'s Dear Colleague letter, dated October the 9th, 1973, be put in the record, and without objection, so ordered. Among these edits was the express retention of the appropriations power of Congress and the role of the federal government as a whole in the budgetary process as it relates to the district. The intent to retain the role of the federal government in the budgetary process went unquestioned for nearly 40 years. In 2012, however, the district unilaterally claimed that this was not the congressional intent of the Home Rule Act and passed a Local Budget Autonomy Act. The Local Budget Autonomy Act was voted on by less than 10% of the eligible voters in the District of Columbia. This act is currently involved in litigation at the federal level regarding its legal status and was previously the subject of extended litigation in both the federal and state courts, with the House Bipartisan Legal Advisory Group having supported the plaintiff challenging the Act's legality. As such, its status remains in legal limbo until the courts issue a final and definitive ruling. The Local Budget Autonomy Act is not settled law, as some have asserted. Further, the GAO, or the Government Accountability Office, issued an opinion in January of 2014 stating that they believe the enforcement of this act would constitute a violation of the Anti-Deficiency Act. As a result, should the district attempt to enforce this act, D.C. employees could face repercussions, including those which stem from the Anti-Deficiency Act violations. These employees could then be subjected to potential administrative penalties and could even be subject to criminal liabilities for violating the Act. Former D.C. Mayor Vincent Gray expressed these concerns of subjecting district employees to the possible administrative and criminal punishments for enforcing the Local Budget Autonomy Act in his April 11, 2014 letter to the Council of the District of Columbia, stating that he would not implement the Local Budget Autonomy Act. So I ask for unanimous consent to enter this letter into the record, and hearing no objection, so ordered. I'd like to thank all the witnesses for agreeing to testify before the committee today. We are fortunate to have attorneys who participated in litigating this issue, the chairman of the Council of the District of Columbia, and a member of GAO's General Counsel's Office, also members of the congressional staff who were involved in the drafting of the Home Rule Act at the time of its passage. I look forward to hearing from each of you on this very important issue. And I now recognize my good friend, Mr. Connolly, the ranking member of the Subcommittee on Government Operations, for his opening statement.
Thank you, Mr. Chairman. Thank you for holding this hearing. I also want to welcome my friend and former colleague, Phil Mendelson, who's chairman of the Washington, D.C. City Council. I approach the subject of home rule as a former local government official, having served in neighboring Fairfax County for 14 years on the governing body, 5 years as chairman of the largest jurisdiction in metropolitan Washington. I know what it takes to produce a budget every year. I know the difficulty of making revenue and expenditure estimates under the best of circumstances. I cannot imagine how a local government, my local government, would function efficiently or effectively if each budgetary decision required congressional approval. I've consistently supported autonomy for the district and would argue that Congress's actions have actually had a deleterious effect on the district, its management, and its residents. I hope the irony of this situation is not lost on anyone watching who support the conservative principles of limited government and states' rights ostensibly. I don't mean my friend, the chairman. I guess the District of Columbia is an ideological carve-out. How is it that a legislative body that struggles to pass its own annual budget and routinely misses appropriations deadlines would nonetheless insist on exercising overall authority and oversight over somebody else's? D.C.'s lack of budget autonomy affects the entire National Capital Region, especially the thousands of my constituents who are civil servants and work every day here in the District of Columbia. Former Virginia Governor Bob McDonnell, a Republican, supported budget autonomy because of the negative consequences for both Virginia and Maryland if D.C.'s fiscal situation is left uncertain, particularly during a federal government shutdown like the one we endured several years ago. Without budget autonomy, if the federal government shuts down, the D.C. government shuts down too, absent a specific exemption from Congress. That means all non-essential D.C. municipal services cease, potentially paralyzing the city and hundreds of thousands of commuters coming into the city, to say nothing of our constituents nationwide who visit D.C. in the millions every year. The past two Republican chairmen of this committee also supported the policy of budget autonomy for the district. My predecessor and friend Tom Davis and Darrell Issa introduced legislation to expand home rule, including bills to give D.C. autonomy. In fact, Tom Davis, my predecessor in this job, continues to fight for budget autonomy as a private citizen. I regret that the committee has seemingly abandoned those bipartisan efforts in recent years. In fact, this committee has gone out of its way to restrict home rule. Last year, the committee and the House, for the first time since 1991, passed a resolution of disapproval on a law passed by the D.C. the Reproductive Health Non-Discrimination Amendment Act. We did it because we could. That law prohibits employers from discriminating against employees based on their reproductive health decisions. More recently, House Republicans passed for the second time this Congress a misguided D.C. voucher bill that was not only not requested by the district, but also has failed to deliver educational results, according to a number of studies and tests. The chairman of this committee seemed to also threaten jail time for the D.C. city mayor for implementing the city's marijuana legalization law, which was adopted by public referendum by the residents of the District of Columbia. And when we do something like that, to me, it's painful irony. First of all, we couldn't do it in Denver. Same referendum, same outcome, because our reach doesn't go to Denver. We do it here because we can, because the Constitution gives us authority over a city that did not yet exist when the Constitution was adopted and was never envisioned to be a modern urban metropolis. In fact, D.C. Superior Court recently upheld the district's Budget Autonomy Act approved by those votes in 2013. While some disagree about how to achieve it, all, including I think most of the witnesses today, will agree on the policy of budget autonomy for the district. To me, it's shameful that the community housing the federal government is not afforded the same rights to self-government as all others across the country. It is time for congressional Republicans to get on board, and this is one case where I would hope, upon reflection, they would actually adhere to their own conservative principles. That government closest to the people is the best form of government. People are entitled to self-determination. There should never be taxation without representation. These are American values, but they certainly are values I've heard from my conservative friends, and I respect them. Let's start to apply them, irrespective of race, irrespective of partisan voting patterns. This is about American rights, and nothing should substitute itself for our enshrinement of those rights and our respect for those rights. I go back.
Thank the gentleman. I thank the gentleman for his opening statements, and we will caution the audience in terms of public displays of either pleasure or displeasure. We would ask you to refrain from that. And so I now recognize the delegate from the District of Columbia, Ms. Eleanor Holmes Norton, for her opening statement.
Thank you, Mr. Chairman. First, I want to welcome Chairman Mendelson. I want to welcome all the witnesses, especially my constituents and others to this hearing. Mr. Chairman, I appreciate that you have given me this time. You're my good friend, even when good friends must disagree, as we do today. I will read what I have to say in order to stay within the time you have given me. You, Mr. Chairman, are known for your well-known kindness, and it's a courtesy, since I am not ranking member, for you to allow me to give an opening statement at this hearing. Of course, this hearing is on my very own district, and it affects only those who live in the District of Columbia. This hearing, however, appears to be a fait accompli. Similar to when the committee went through the motions last month marking up the District of Columbia School Vouchers Bill, the committee knew that the bill could only be enacted on an appropriation bill, that there was not the support in the Senate. And Chairman Jason Chaffetz had already requested that the matter be put on the upcoming appropriation bill even before we had that hearing here. This hearing seems designed to lay the predicate for using the appropriation process yet again to try to overturn, block, or preempt the Local Budget Autonomy Act of 2012, which was ratified by 83% of the D.C. voters. The evidence for this is transparent. Speaker Paul Ryan, spokesperson, told the press that Republicans are considering, quote, legislative options for the Budget Autonomy Act. The three top House Republican leaders have filed amicus briefs expressing their view that the Budget Autonomy Act is invalid. The House Appropriation Committee has said that the Budget Appropriation Act is invalid. By calling legal experts, the subcommittee is trying a complicated legal matter in the court of public opinion, and most will not understand much of the legal machinations we discuss here today because they are normally discussed in a court of law. Only the courts can determine the validity of the Budget Autonomy Act. Indeed, the Budget Autonomy Act has been litigated for the last 2 years, with courts reaching conflicting conclusions. Yet the Act is the law of the land. The Congress did not disapprove the Budget Autonomy Act during the congressional review period, and the only court order in effect on the Budget Autonomy Act upheld its validity. What is within the committee's authority is to remove federal restrictions that harm the finances and operations of the D.C. government. The last 2 Republican chairmen of the committee studied this issue closely, Tom Davis and Darrell Issa, and sought budget autonomy for the District of Columbia. As Mr. Davis has said, the benefits of budget autonomy for the district are numerous, real, and much needed. There is no drawback, end quote. Indeed, even the Republican witnesses here who have taken a position on the policy of budget autonomy support it. Control over the dollars raised by local taxpayers and businesses is central to local control, one of the oldest principles of the United States government, and a much cited principle of congressional Republicans in particular. Budget autonomy also has practical benefits for both the district and the federal governments. For the district government, it means lower borrowing costs, more accurate revenue and expenditure forecasts, improved agency operations, and the removal of the threat of federal government shutdowns. For Congress, it means not wasting time on budget line items. It never amends. For the federal government, it means that the municipal services, that government, our government, relies on to function will not cease during a federal shutdown. To its credit, Congress has begun to recognize the hardships caused by the lack of budget autonomy. Since 2014, for the first time, we've been able to keep the Congress from involving the district, and Congress has exempted D.C. from federal shutdowns. Congress loses nothing under budget autonomy. This is not statehood. Under the U.S. Constitution, Congress has the authority to legislate on any district matter, including its local budget at any time. This year's Republican budget made the case for budget autonomy, and I conclude with what my colleagues said in their own budget. This budget would give our states and local municipalities the freedom and flexibility to meet the unique needs and challenges of their communities. We are humble enough, said my colleagues, to admit that the federal government does not have all the answers. Putting our faith in the people will respect and restore the principle of federalism in America, end quote. Mr. Chairman, I rest my case. Thank you very much.
I thank the gentlewoman for her comments. I will hold the record open for 5 legislative days for any member who would like to submit a written statement. We will now recognize our panel of witnesses, and I'm pleased to welcome Ms. Etta Emanuela Perez, Managing Associate General Counsel at the Office of General Counsel at the U.S. Government Accountability Office, Mr. Jacques Dupuis, all right, a retired partner at Greenstein, Delorme and Lux, and a formal counsel for the Subcommittee on Government Operations and Reorganization. Mr. Philip Mendelson, Chairman of the Council of the District of Columbia. Mr. Irvin Nathan, Senior Counsel at Arnold and Porter and former Attorney General of the District of Columbia, and Mr. Brian Netter, Partner at Myers Brown. Welcome to you all, and pursuant to committee rules, all witnesses will be sworn in before they testify. So I'd ask that you please rise and raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect that the witnesses have answered in the affirmative. Please, thank you. Please be seated. And so in order to allow time for discussion, I would ask that you please limit your oral testimony to 5 minutes. Your entire written statement will be made part of the record, and you're now recognized for 5 minutes.
Good afternoon, Mr. Chairman, Ranking Member, and members of the subcommittee. Thank you for the opportunity to discuss our legal opinion concerning the effect of the District of Columbia's Local Budget Autonomy Act. The Budget Autonomy Act attempts to change the federal government's role in the district's budget process by removing Congress from the appropriation process of most district funds and by removing the president from the district's budget formulation process. GAO concluded that provisions of the Budget Autonomy Act that attempt to change the federal government's role in this way have no legal effect. In the District of Columbia Home Rule Act, Congress established a district government and delineated its budget process. The Home Rule Act, as well as the Anti-Deficiency Act and the Budget and Accounting Act, serve and protect two important constitutional powers reserved to the Congress: its power to exercise exclusive legislation in all cases whatsoever over the district, and Congress's constitutional power of the purse. GAO addressed the conflict between the Budget Autonomy Act and the Anti-Deficiency Act and the Budget and Accounting Act. The Anti-Deficiency Act bars officers and employees of the U.S. government and the government of the District of Columbia from making or authorizing expenditures or obligations exceeding the amount available in an appropriation. The Budget and Accounting Act requires the head of each agency, which includes the District of Government, to submit a budget request to the President for transmission to Congress. The Home Rule Act states that the Council may not amend or repeal any act of Congress which is not restricted in its application exclusively in or to the District. In addition to applying to the District, both the Anti-Deficiency Act and the Budget and Accounting Act apply to all officers and employees of the United States and heads of federal agencies. Thus, the Home Rule Act bars the District from amending or repealing these statutes. We concluded that without affirmative congressional action otherwise, the requirements of the Anti-Deficiency Act continue to apply, and district officers and employees may not obligate or expend funds except in accordance with appropriations enacted into federal law by Congress. The district government also remains bound by the Budget and Accounting Act, which requires it to submit budget estimates to the President. We examined the legislative history of the Home Rule Act and found that it supported the conclusion that the Anti-Deficiency Act continues to apply to the district. Although the Senate version of the Home Rule Act would have granted considerable fiscal autonomy to the district, the Conference Committee adopted the House provisions that required that the district submit its budget to Congress. The stated reason was that they did so to preserve the process through which Congress appropriates amounts for the district. By considering and explicitly rejecting the idea of granting greater budget autonomy to the district, Congress reserved to itself the authority to appropriate funds for the district. We considered other arguments made in support of the Budget Autonomy Act. One such argument was that Congress granted the district a permanent appropriation of the district's local funds that would make local funds available without further action by Congress. We disagree. By law, the making of an appropriation must be expressly stated and cannot be inferred or made by implication. Congress enacts appropriations by identifying the source of funding and authorizing the obligation and expenditure of those funds. Congress has not provided the district with such authority. A further argument was that the purpose and text of the Anti-Deficiency Act would be satisfied when the district government, rather than Congress, enacts an annual appropriation. Again, we disagree. Pursuant to the Constitution, both the appropriations power and the exclusive power to legislate over the district belong to Congress. As the cornerstone of fiscal laws enacted by Congress to implement its power of the purse, the Anti-Deficiency Act clearly applies to the district, both by its very terms and by the terms of the Home Rule Act, reflecting Congress's decision to expressly limit district spending to amounts Congress appropriates. We also considered whether it was legally significant that Congress has not enacted into law a resolution disapproving of the Budget Autonomy Act. Since the Home Rule Act provided no authority to enact the Budget Autonomy Act, and acts taken without legal authority are void at the outset, it is of no legal significance that Congress did not enact a resolution disapproving of the Budget Autonomy Act. GAO does not take a view on the merits of Congress granting greater budget autonomy to the district. Under the framework that the Constitution has established, only Congress has power to determine the nature of the district's process. In the Home Rule Act, Congress clearly established that it continues to retain sole authority to appropriate amounts for the district. If Congress wishes to change the district's budget process, it may, of course, do so by enacting legislation. We are aware of court rulings issued after our January 2014 legal opinion. GAO's analysis and conclusions are consistent with and compelled by Congress's constitutional authority to exercise exclusive legislation over the district and with the laws Congress has enacted pursuant to that authority. Thank you, Mr. Chairman and Ranking Member. This concludes my statement, and I'd be pleased to answer any questions you may have.
Thank you so much. Mr. Dupuy, you're recognized for 5 minutes.
Thank you very much, Mr. Chairman, members of the committee. And thank you for inviting me to testify today with regard to congressional intent in the passage of the D.C. Home Rule Act of 1973. I was subcommittee counsel to the subcommittee of the House D.C. Committee, which held the hearings on and initially drafted the D.C. Home Rule Bill in 1973. I was also very actively involved in the further drafting of the bill and political strategy pertaining to the bill in the full House District of Columbia Committee prior to House floor consideration of the bill and in the House Senate Conference Committee. I'm also co-author with Jason I. Newman of a Law Review article on the Home Rule Act published in 1975 by the American University Law Review. I also participated in the litigation brought by the Council of the District of Columbia against then-Mayor Vincent Gray and Jeffrey DeWitt in the United States District Court in May 2014, along with 2 other former committee staff members and Mr. Newman as amici curiae. I've submitted a copy of the brief prepared by the 4 of us as amici to this committee. I appear today solely on my own behalf. I would also like this committee to know that although I testified today that the Congress did not intend to delegate to the D.C. Council or district voters any authority over local revenues through the charter amendment or any other process, I am personally a fervent believer in and advocate for the rights of the citizens of the District of Columbia to fully enjoy all rights of self-determination. First, as indicated in the brief, the Home Rule Act contains numerous limitations and restrictions on the powers and authority of the then-to-be-created local government. Included among such limitations and restrictions were the charter amendment process, the authorization of a federal payment, the budget process, and borrowing and spending. Such matters were not contained within the charter, were not to be subjected to a vote by district residents, and were not subject to the charter amendment process. In essence, such matters, with numerous others, were to be off limits to the local government. Secondly, when Congress adopted the Home Rule Act, it was clearly understood that the Act did not provide the local government with budget autonomy. Specifically, there was to be no change in the existing line item congressional appropriations role. Furthermore, no distinction was made between local and federal or any other category of revenues. Indeed, Section 603A of the Act states that, quote, "Nothing in this Act shall be construed as making any change in existing law, regulation, or basic procedure and practice relating to the preparation, review, submission, examination, authorization, and appropriation of the total budget, and I emphasize the words total budget, of the District of Columbia. This provision is not part of the charter and cannot be changed by the charter amendment process. I direct the committee to the brief, which, as I indicated, has been submitted for a much more detailed discussion of these important matters. I'm happy to respond to questions, and I thank you.
Thank you, Mr. Dupuy. Chairman Mendelson, you're recognized for 5 minutes.
Thank you, Chairman Meadows, Ranking Member Connolly, Congressman Norton, and other members of the committee. I appreciate this opportunity to testify. Although the topic for today's hearing is D.C. Home Rule, examining the intent of Congress in the District of Columbia Home Rule Act of 1973, I want to speak more generally about the purpose and need for budget autonomy for the government of the District of Columbia. With all due respect, the fundamental question before us is not whether budget autonomy, as enacted by the Council and the voters, is legitimate or consistent with the intent of the 93rd Congress. Rather, the fundamental question is whether Congress today wants budget autonomy for the district. I frame the question this way because, as you know, Congress has plenary authority over the district. We've made our case in court that the Budget Autonomy Act of 2012 is legitimate. But that really doesn't matter if you, a majority of the members of the House and Senate, want to overturn it, because you can do so. When we talk about budget autonomy, we are talking about only the local dollars portion of our budget. Many people believe the district's budget is comprised of federal dollars because it has been appropriated by Congress in the same process as the budgets of the federal departments. You know it isn't. In fact, 74.6% of our budget comes from locally imposed fees and taxes. So I want to make 3 points. First, why budget autonomy is a good thing, that having budget autonomy is best practice for the fiscal management of the district. Second, why Congress shouldn't want exclusive budget authority over the district. And third, that while budget autonomy makes a big difference for the district, it does not make a big difference for Congress. Why is budget autonomy a good thing? There are many reasons. It allows us to adopt our budget more quickly. It allows us to make changes, especially reductions in an economic downturn, immediately. It also allows us to move quickly to implement a solution to emerging service needs, for instance, responding to a spike in homicides. It gives us flexibility to change our fiscal year so as to better align it with the school year or the fiscal year of regional authorities. It also gives us the flexibility to budget or spend across fiscal years, such as rewarding program managers who save funds by allowing them to carry those funds forward. Budget autonomy severs our ability to spend from the uncertainties of the federal appropriation process. I mean, to put it bluntly, government shutdowns and the failure to appropriate timely. It also enables us to tighten the period between budget preparation and implementation. Currently, the budget beginning October 1st is adopted 4 months earlier, in May, and based on revenue estimates prepared 7 months earlier, in February. All of these positives from budget autonomy can be summed up in one simple fact. Budget autonomy helps our credit rating on Wall Street. Being tied to the federal appropriations process is a negative rating factor. Congress shouldn't want exclusive budget authority over the district. Some 145 years ago, Congress dissolved the territorial government of the District of Columbia and assumed direct control. It might have made sense during the century between Reconstruction and Home Rule to treat the district as if it were an agency of the federal government, like the Department of Agriculture. In that time, Congress appropriated large federal payments each year as part of our budget. Accordingly, both houses of the Congress had committees focused expressly on the district, and substantial resources were devoted by you to running the district. All that has changed. There is no longer a House or Senate district committee. While I'm sure our annual budget is carefully reviewed, Congress no longer rewrites it. Indeed, our budget is almost an afterthought in the federal appropriation process, as evidenced by our treatment during the last government shutdown. Congress wasn't sure it could trust us to handle our own finances when we got limited home rule in 1974. But all of that has changed. In many ways, we have today the best financial situation of any large city in the nation. Congress will always have budget authority over us because it has plenary authority. But Congress should no longer want to maintain exclusive budget authority over the district. Not only is it a drag, as I outlined in my first point, but it is no longer necessary, and Congress is no longer set up for it. While budget autonomy makes a big difference for the district, it does not make a big difference for Congress. Congress has failed to adopt our budget on time in almost 20 years, has not made any substantive changes to our local funds budget since at least the control board some 15 years ago. In recent years, the Congress has tried to help the district by giving us authority to increase appropriations slightly when revenues increase and to enable us to spend our local budget without an appropriation during a government shutdown. These congressional actions actually support our argument that allowing local budget autonomy won't make a big difference for Congress. What does Congress give up or lose with budget autonomy? Nothing. If you are worried we will misspend our money, Congress still has plenary authority to step in at any time. Congress also can have oversight hearings on our spending or on our local programs at any time, which you can do with or without a pending appropriation. As for riders, I would suggest hesitantly that there will still be a Federal Appropriations Act for the district. The pros versus the cons are overwhelming. The district is better off with it, not just as a home rule issue, but as a fiscal matter. Meanwhile, Congress gives up nothing fundamental, and budget autonomy for our local dollars better matches the current structure and practice of the Congress. As I said at the outset, the essential question before us today is not what was the intent of the 93rd Congress, but whether Congress today will support budget autonomy for the district. Thank you.
Thank you, Chairman Mendelson. Mr. Nathan, you're recognized for 5 minutes. If you can hit the mic there, yeah. Red button, or it will be red when you hit it.
Thank you. Thank you for the invitation to appear here today to testify about the validity of the District of Columbia Budget Autonomy Act, which was passed by the D.C. Council in 2012 and ratified by the district voters in 2013. During that period, I served, as you mentioned, as the Attorney General for the district. I want to make clear that my views today about budget autonomy for the district are the same as when I was the D.C. Attorney General. I believe that budget autonomy for the locally raised revenues of the district is sound and appropriate public policy, and for the reasons that have been described by the ranking member, by Congresswoman Norton, and by Chairman Mendelson, I think they should be enacted by the Congress. And if it were enacted by the Congress, it would be signed by the President. However, unilateral legislation by the D.C. City Council enacting such a budget autonomy contravenes several explicit provisions of the Home Rule Act of '73, contravenes the legislative bargain that led to the passage of the Home Rule. It violates, as said by GAO, the longstanding Federal Anti-Deficiency Act. And in my view, the Council's Budget Autonomy Act is null and void, and implementation of it may put D.C. office holders and their actions in legal jeopardy. This is the same opinion I expressed when I was the Attorney General. I want to make clear that my views are shared by the career lawyers at the Attorney General's office. They are shared by the current elected Attorney General, who courageously took this position in litigation during his election campaign and in litigation in the federal and local courts. And it's the view of the only federal court to look at this issue. The legislative history is clear, and so is the language of the statute. The legislative history is that the Home Rule Act was not going to pass until the Diggs Compromise was reached, and you mentioned the letter to the dear colleague letter. That compromise gave limited home rule to the district and left budget authority with the Congress. I note that neither Mr. Mendelson in his testimony nor the outside counsel for the city mention in their prepared testimony the language of the law, the Diggs Compromise, or Federal Judge Emmett Sullivan's decision. I believe that Judge Sullivan's decision is a very sound one and is likely to be followed by courts that deal with this issue in the future. What's important to recognize is that there is no court decision that has yet been decided that is going to be binding on any other court that is likely to consider this matter in the future. There could have been if Mayor Bowser's outside lawyers had allowed the matter to be decided by the Federal Court of Appeals. But they asked the Federal Court of Appeals to dismiss the case as moot and asked it to be remanded to the Superior Court. When they asked it to be remanded, they said they were going to seek dismissal of the action in the Superior Court and claimed that the action was not ripe as to the CFO, who was another party to that case. But when they got back to the Superior Court, they changed positions and said it was urgent to have this resolved, and they asked the Superior Court to decide it. And as you know, the Superior Court sided with the council and said that this was valid. In my testimony, I discussed the deficiencies of the Superior Court decision, and I think what's most important is that in a future litigation, neither the Superior Court's decision nor Judge Sullivan's decision is going to be binding, but I believe that as a result of the council's legislation, there will be future litigation. There's already a case pending in the federal court, as you mentioned, and after this takes effect, it is inevitable, it seems to me, that there's going to be future litigation. And in the future litigation, I think most judges are going to find Judge Sullivan's decision in validating this act is going to find that persuasive and not find the Superior Court persuasive. What I think, and what has troubled me all along, is that this is going to lead to confusion and chaos in the district's budgeting and finances. And I don't believe that's in anybody's interest, certainly not the residents of the District of Columbia, and not in the congressional interest. I think everyone has an interest in seeing that there's no confusion and chaos in the budget or financial affairs as a result of litigation over the Budget Autonomy Act. That kind of confusion would not be fair to the D.C. residents or the many people who work in the district every day or tourists who come and rely on the services. Now, the best way to prevent such confusion or uncertainty is for Congress to enact budget autonomy, as the D.C. delegate has urged for years in legislation, and as the President has recommended, and as the referendum shows that the D.C. residents desire. You know, I think it's pretty clear that, as Mr. Mendelson has said, that the officials in the District of Columbia are responsible stewards of the D.C. budget, and they would do a good job. They've done a good job, and I think they would continue to do a good job of maintaining fiscal responsibility. And as noted, this would be consistent with congressional responsibility, which can always pass legislation if Congress is not satisfied with a particular policy or expenditure of the D.C. government. So I think that the right solution to avoid this future litigation, which is going to be confusing and unfortunate, is for Congress to recognize the validity of what has been said here by Mr. Mendelson and by Congresswoman Norton, and to pass budget autonomy and clarify the situation, which at the moment is, it could be very deleterious to the district and therefore to the nation. Thank you.
Thank you, Mr. Nathan. Mr. Netter, you're recognized for 5 minutes.
Thank you, Chairman Meadows, Ranking Member Connolly, and members of the subcommittee. My name is Brian Netter, and I'm a partner in the Washington, D.C. office of the law firm Mayer Brown. Along with my co-counsel, Karen Dunn of Boies, Schiller, and Flexner, I was retained on a pro bono basis by the Council of the District of Columbia to independently assess whether the Local Budget Autonomy Act of 2012 complies with federal law, including the Home Rule Act of 1973. I was not then and am not now an advocate for any policy outcome. Questions about why budget autonomy is desirable for the district and for Congress are better directed to Chairman Mendelson. My team's objective was to determine whether the Budget Autonomy Act comports with federal requirements. When we began investigating the legal issues presented by the Budget Autonomy Act, various political actors had taken positions already as to the validity of the act. But so far as we were aware, none had undertaken the no stones unturned sort of investigation warranted by the circumstances here. We therefore undertook an exhaustive investigation that began with a review of the 4,000-page set of committee proceedings from 1973, and ultimately resulted in us contacting each of the living members of Congress who served on the relevant committees in 1973, and as well as consulting the personal archives of key members and senators who have died. The Home Rule Act represented a bipartisan success of the civil rights era, overcoming long-standing resistance that had been blamed on racist attitudes toward the district. Congress came together to create for the District of Columbia a government for the people, a government by the people, of the people, and for the people. The centerpiece of the Home Rule Act was the district's charter, which Congress envisioned as akin to a state constitution. In 1973, Congress created a process through which the district could propose amendments to the charter. Those amendments would become law only if both chambers of Congress affirmatively approved the amendment by enacting a concurrent resolution. Because Congress retained for itself the ultimate authority to approve those amendments, the limitations on the district's charter amendment authority were few and narrow. In 1983, the Supreme Court's decision in INS versus Chadha invalidated legislative procedures such as the procedure for amending the district's charter. Accordingly, Congress needed to change the process. Congress decided to make amendments proposed by the district presumptively valid unless Congress enacted and the President signed a joint resolution of disapproval. In so doing, however, Congress did not alter the narrow set of limitations on the district's charter amendment authority that had been enacted in 1973 when Congress's affirmative assent was required. We investigated each of the supposed limitations on the district's authority that opponents of the Budget Autonomy Act used to question its legitimacy. In particular, we reviewed the reports that were supplied by GAO and by Mr. Nathan, but we found the concerns in those reports to be legally unfounded. In our system of laws, where there is a dispute about the interpretation or validity of a statute, it is the province and duty of the Judicial Department to say what the law is. And so we filed a lawsuit so that the issue could be resolved as our Constitution contemplates. This was a high-profile case that received attention from thoughtful commentators. The Superior Court had before it briefs from the three parties, the Council, the Mayor, and the Chief Financial Officer, as well as friend-of-the-court submissions from 11 different groups offering their views. Those groups included scholars on federal budget law, legislative interpretation and local government law, and legislators and staffers who participated in the drafting of the Home Rule Act in 1973. There obviously isn't sufficient time for us to discuss all the many contours of those briefs. However, they provide a very detailed and sophisticated understanding of what Congress was doing, the context in which it was doing what it did, and how subsequent events, including the Supreme Court's decision in Chadha, affect the analysis of the Home Rule Act today. On March 18, 2016, the Superior Court for the District of Columbia issued an opinion upholding the Budget Autonomy Act and offering a detailed explanation for why the opponents of the legislation were incorrect. The Superior Court permanently enjoined all district officers and officials to enforce all provisions of the Budget Autonomy Act, and the time to appeal has now expired. What this means is that budget autonomy is indisputably the law of the District of Columbia. Congress retains its plenary authority over district affairs and will have the same review period over the district's budget as it has over any other legislation that originates from the D.C. Council. But in circumstances in which Congress fails to act, the default rule is now that the D.C. government will not be paralyzed and will instead be permitted to operate. I thank the subcommittee for the opportunity to discuss these important matters, and we would be pleased to answer any questions.
Thank you, Mr. Netter. The chair recognizes the vice chair of the subcommittee on government operations, the gentleman from Michigan, Mr. Walberg.
Thank you, Mr. Chairman, and thanks to the panel for being here. Mr. Dupuy, you were counsel to the committee responsible for the Home Rule Act at the time of its drafting. Can you describe for us the extent to which the act was debated at the committee level?
Yes, Congressman, the debate on the so-called Diggs Compromise occurred after the bill had been reported to the floor, and it became clear to the majority of the committee that there were insufficient votes to pass the bill as then constituted. The majority of the committee members then chose to support a substitute amendment to the committee's own bill, a somewhat unusual procedure, and it was debated extensively on the floor. It was the subject of the Dear Colleague letter that the chairman mentioned.
It was debated in committee as well?
It was not debated.
So it was sent to the floor?
It was sent to the floor, that's correct.
Okay.
And then, of course, it was the subject of much discussion in the Senate-House Conference Committee.
How was it altered out of committee on the floor? How was it altered?
The provision dealing with the basic appropriations process and the basic budgetary process was not amended. It was very clear and made clear by the members of both parties that that topic was essentially not debatable and had to remain as it was and as it was passed by the House.
Was the 1973 Act the only time either chamber introduced home rule legislation while you were working in Congress?
The Senate had for years introduced home rule legislation. The House had not done so until Chairman Diggs became chairman of the House District of Columbia Committee, and so essentially that was the first time that the House in decades, if not longer, had considered home rule.
But it didn't pass any of those efforts prior for any specific reason that you could determine?
There was the House D.C. Committee prior to the time when Chairman Diggs and others became a majority of the committee. I think it's fair to say was not particularly disposed towards granting the city much authority and retained as many powers as it could. So there was a disinclination by the prior committee to undertake any legislation that would generally grant more power to the city.
Why was the budget autonomy removed from the final home rule legislation if it was included in earlier versions?
It was decided as the bill got closer to being considered on the House floor that there were just not sufficient votes to pass the bill as it had been prepared on this topic prior to House consideration. There was considerable opposition from the House Appropriations Committee and from key members of Congress to the home rule bill as it came out of committee prior to the Diggs substitute and the so-called Diggs Compromise.
Was the removal of the budget autonomy from the Home Rule Act an intentional action by Congress?
Yes, very clearly so.
Very clearly intentional?
Yes.
What's the importance of Section 603 in the Home Rule Act as it relates to the budgetary process?
I think that section is very clear that the congressional appropriations process and powers were not to be delegated to the new local government.
Thank you. I yield back my time.
I thank the gentleman. The chair recognizes the ranking member of the.
Because of the exigencies of schedule, Mr. Chairman, I would ask that my colleague, my friend from Missouri, Mr. Clay, be recognized at this time, reserving my right to revert back to.
The chair recognizes the gentleman from Missouri, Mr. Clay, for 5 minutes.
Thank you so much, Mr. Chairman, and thank my friend, Mr. Connolly, as well as Ms. Norton, for your indulgence. Chairman Mendelson and Mr. Nathan, even with budget autonomy, all the federal financial mandates on the District of Columbia remain in place. These include an independent chief financial officer, a borrowing cap, an emergency and contingency reserve accounts. Moreover, the Financial Control Board that Congress put in place in 1995 to address the district's financial crisis automatically comes back into existence if the district fails to meet any of 7 financial conditions, such as not meeting its payroll for any pay period. I would like both of you to answer this question. Under budget autonomy, is there any reason to be concerned that the district will not balance its budget or otherwise lose its fiscal discipline? Mr. Mendelson first. Go right ahead.
Thank you, Congressman Clay. You're correct in your question that those protections remain in place and that we have requirements under the law with regard to certain processes and to ensure that we have a balanced budget and that we can make payroll and that we maintain good fiscal order. I would want to add this, though. Yes, there's a requirement in the law written by Congress about reserves, that we have to have 2 reserves. In fact, we have 4 reserves. There are 2 that we've added. And in fact, the reserves that we have are substantially more than what Congress requires. And in fact, our goal is to achieve reserves equivalent to 60 days of operating expenditures. That's far in excess of the congressional requirement. And we are currently at, I believe, 49 days of reserves. In addition, you mentioned the borrowing cap, which is in the Home Rule Act. It's an 18% of revenues. No more than that can be dedicated to interest payments. Well, we passed a local law that says 12%. So we are far better than what the federal requirement is. But I would add that there are some other things that we have in place. And this is something that you see across the country with regard to local jurisdictions and states as well. And that is how they're doing with their unfunded pension liability and the other post-employment benefits. And while that's not written into the Home Rule Act, we see city after city struggling with a huge unfunded liability. Well, on our retirement funds, our unfunded liability is 0. We are at 105% funded. And with regard to the other post-employment benefits, where city after city has 0, and that is to say they have 100% liability, we are 120% funded. There is no other jurisdiction in the country, when you put the 2 together, that's as good as the District of Columbia.
Thank you for that response. Mr. Nathan.
Well, I agree with the question. Those restrictions are all in place and are adhered to by the District of Columbia. My concern is, as I've expressed it before, that with the Local Budget Autonomy Act, which will allow officials of the district to spend money that is not appropriated by Congress, that people could find that there are some violations of both the federal law and the Home Rule Act, and that, for example, you said we have to meet, the district has to meet the payroll. If those people are paid by funds that have not been appropriated by Congress, there would be an issue as to whether or not the district is in compliance. And if it's not in compliance, there is a chance that the control board could come back into effect, which is not a position to be desired at all. And so, again, this is a reason why the passage of the Budget Control Act by the Council was not well advised, but I urge the Congress to think about passing it.
Fair enough, and I agree with that. And, Mr. Chairman, and I think the conversation needs to happen on this side now with the impetus of what Mr. Nathan said, that we are reasonable people. We are guests of the people of the District of Columbia. They are gracious, they are welcoming, they host us as the seat of government. We need to be reasonable and realize that they have evolved too since 1973.
Right.
We need to be reasonable about that. And I don't know if you're willing, but I wanted to kind of share some of the history with the gentleman from Michigan about how that compromise came about in 1973. The resistance wasn't on your side of the aisle, it was on our side of the aisle because of the seniority system. And you had the mostly Southern Democrats that controlled that committee with the District of Columbia, and that's how the compromise came about.
Are you saying this was all the Democrats' fault?
I am. I'm admitting that, but I think that the Republicans
I believe the gentleman's time is up.
I know my time's expired.
All right, I think the gentleman, the chair recognizes himself for a series of questions. Ms. Perez, let me ask you, does the Anti-Deficiency Act apply to the District of Columbia?
Yes, Mr. Chairman, it does. The Anti-Deficiency Act, by its own terms, applies not only to officials and employees of the U.S. government, but specifically to officials and employees of the district government. In addition, the Home Rule Act states that the Anti-Deficiency Act continues to apply to the district and also includes a section that says that district funds continue to be appropriated by Congress, so employees can only obligate in accordance with congressional appropriation.
So is it GAO's opinion that the District of Columbia would be in violation of the Anti-Deficiency Act in the event that the Budget Autonomy Act is implemented?
We would only opine on an Anti-Deficiency Act violation if we had facts before us. That is the nature of how we do our opinions. But certainly, we think it would be advisable for the district to consider the implications of the Anti-Deficiency Act. It does say that district employees may not obligate or expend funds except in accordance with an appropriation enacted by Congress, or also that they cannot obligate or expend funds before they receive such an appropriation.
So, Chairman Mendelson, with that information before you, do you believe that it's prudent to put potentially D.C. employees or those who would expend the funds at a disadvantage as it relates to the Anti-Deficiency Act and potential punishment therewith?
Well, I would have that concern, Chairman Meadows, except that we thought the way to resolve that would be to seek a declaratory judgment in court, and that was why the Council initiated the litigation. And the litigation, as has been largely described, was filed in Superior Court, and then it was removed to Federal Court. And the circuit, as I recall, vacated the decision and remanded it to the Superior Court.
Well, it was actually the mayor that they didn't judge it on necessarily on the merits of that particular case, is my understanding. I've read hundreds and hundreds of pages. I know more about home rule than I've ever cared to know about and the history thereof. And so what we have is a superior court that has made a judgment on federal law where there should be some question jurisdictionally with regards to that particular decision. And so in light of the GAO's concern, do you not share that same concern for D.C. employees?
The short answer would be no. We have a court order, and the court order—
I would suggest that maybe you rethink that, because I think it's Mr. Chairman, it is a great concern of mine, if they were my employees or under my direction, to put them in a legal battle that is still ongoing, still being litigated, but potentially has the threat of not only fines but criminal violations.
Well, Chairman Meadows, there are two parts to this. One is whether we comply with the Anti-Deficiency Act. And not only do we comply with the Anti-Deficiency Act, in fact, we have a local Anti-Deficiency Act that's stronger than the federal act with regard to our spending. So with regard to that issue, there isn't an issue. The other part of it has to do with whether we could spend our local dollars without an
that's
appropriation.
a different philosophy. So let me go a little bit. And,
Sure.
and Mr. Nathan has put forth a number, and I've read things that you actually had submitted in terms of briefs and other opinions that I find very illuminating, because your opinion is that you want budget autonomy personally. Is that correct?
That's correct.
And so your personal opinion is that you believe D.C. should have budget autonomy, but the way that they went about it was, in your opinion, not legal. Is that correct?
That's correct. But Congress has the ability to do it, and I think it's good policy and should be done.
Well, and so as we look at that, Mr. Netter, let me come to you, because you have unbelievably found all kinds of information that I have not been able to find in reading hundreds, if not several hundred pages of documents in the history and going through. How do you reconcile paragraphs 601, 602, and 603 that shouldn't, in my mind, reading the clear language, are not amendable, and yet what we've done is the D.C. has tried to amend those through this particular action? How do you reconcile that?
Well, Chairman, I disagree vehemently that the district has tried to amend any of those provisions. And, there are a number of provisions and sub-provisions within section.
That's an interesting fact, because 603 is very clear in terms of what it is, and it basically spells out in the context of how it's written this whole discussion that we're having.
It does, but I disagree with your conclusion. So Section 603A says nothing in this act shall be construed as making any change to existing law. And that sort of provision, which I'm sure the Chairman is quite familiar with, is a provision that is a rule of construction for the particular statute being enacted that explains how the statute is to be interpreted. And our litigating position, which was adopted by the Superior Court, was that Section 603A explains for everybody to understand what Congress was achieving in 1973.
Yeah, but let's go on. So let's look at other paragraphs there, because if you look at the original intent of Home Rule and in the 100 paragraphs, if you look at really the amendment process in the 300 paragraphs, and then you go to 601, 602, and 603, not just those, but if you look at the details of that, I don't see how you can find any other conclusion other than it was truly the intent of Congress to keep the appropriation process as a function of Congress and not to allow it to ever be amended.
Well, there are two separate issues there, Chairman. The first is whether Congress was granting budget autonomy in 1973, and we agree that it wasn't. The second question, however, is whether Congress was intending to prevent the district from proposing any changes to its budget process under the amendment authority that existed in 1973. Now, as I indicated in my opening statement, at the time, both chambers of Congress needed to acquiesce, needed to affirmatively agree with any proposal.
Which they did with the Diggs Compromise. And so if there's the Diggs Compromise, that if you go back through the congressional record, it's very clear that the appropriators, which, as my friend from Missouri talked about, were Democrats at the time, wanted to maintain control. Did you not find that in your research? I know you didn't argue it, but did you not find that in your research?
No, we certainly did argue that. We acknowledged that they wanted to maintain control, and they did maintain control.
Well, then is that not the intent of Congress in 1973?
But the intent of Congress was also to create an amendment process, and the district here followed that amendment process under which—
Well, I respectfully disagree, and I'm out of time, but I will recognize the ranking member, Mr. Connolly, for a very gracious 7.5 minutes.
My friend is always fair. I thank him. You know, the King of Siam and the King and I, when faced with all kinds of inexplicable problems, would say, it's a puzzlement. There's a lot to sort out here. Let me start with you, Ms. Emanuele Perez. You are the Managing Associate General Counsel. Has somebody designated you as the judicial arbiter of constitutional issues or even adjudication of judicial rulings?
No, Mr. Ranking Member. The GAO—
My name is Connolly. You can address me by my name.
No, Mr. Connolly. GAO has statutory authority to issue legal opinions to Congress on the use of appropriated funds, to interpret the applicability of the Anti-Deficiency Act, and we've been doing so since 1920.
Even when there's been an adverse judicial ruling?
Well,
you get to ignore a judicial ruling?
Our legal opinion, we issued it in January of 2014 prior to the opinions.
But in your testimony today, you therefore took no cognizance of the fact there's in fact been intervening judicial ruling.
Well, we have not issued another
I understand,
legal
but what am I supposed to do as a member of Congress with your testimony as if there were no court and no court opinion? You're supposed to be advising us.
And
it seems to me you have a legal obligation, Ms. Perez, to take cognizance of a judicial ruling when you come here under oath and testify. And you've ignored the fact that there was a judicial ruling, which I think taints your testimony.
No, sir, I would not agree that we've ignored it. What we've said, and what I said in my testimony—
Well, you didn't even mention it.
No, I did. I said that we acknowledge that there are court cases. What we have stated is
that— Court cases? There is a court case.
Yes, and—
The dispositive court case is in front of us. Now, Mr. Nathan shares your legal opinion, which I'm going to get to, about that notwithstanding, it still requires an act of Congress, because he thinks, and apparently you think, that Mr. Mendelson and his friends, colleagues on the City Council, have put themselves in legal jeopardy, notwithstanding a court ruling, because of the Anti-Deficiency Act. Is that correct?
What we have interpreted is that the Anti-Deficiency Act, pursuant to Congress's constitutional powers in this case, is that it continues to apply. That's our opinion.
Okay, but let me explore. Your opinion is, even though there's been a court ruling that Mr. Mendelson and his colleagues are relying on, nonetheless, somebody somewhere is going to find them in legal jeopardy, irrespective of a court ruling that they cite as their legal protection. You really think someone's going to prosecute him and his colleagues in light of the legal ruling they're relying on? Really?
Mr. Connolly, what we're saying is that we believe that Anti-Deficiency Act continues to apply, and so therefore, because it continues to state in codified law that it applies to the District of Columbia, in addition to in the Home Rule Act, that we always advise agencies and entities to follow the Anti-Deficiency Act.
Well, if I were a member of the D.C. City Council, quite frankly, though you put that nicely, and same with you, Mr. Nathan, I would call it intimidation. By citing anti-deficiency and their exposure, irrespective of a court ruling, I don't know how else to conclude if I were a member of the D.C. City Council, other than you're warning me I could be in legal jeopardy, I should ignore a court ruling, or I can ignore a court ruling. Now, I just think that's improper. I think that's not useful counsel for them, and it's certainly not welcome counsel for me as a member of Congress seeking guidance through a very nettlesome set of problems.
May I
Mr.
respond?
Nathan, did you want to comment?
Yes, I do. First of all, the statute, the Anti-Deficiency Act, which has been in existence for over 100 years, is, of course, the supreme law of the land. That's a congressional statute. And everyone, including district officials, have to comply with that law.
I have to interrupt you because I'm running out of time, Mr. Nathan. Let me ask a question pursuant to what you just said.
Okay.
So is it your testimony that the court ignored the Anti-Deficiency Act in giving its ruling?
It's my view that the court got it completely wrong.
Aha.
In the first place, I think what's important is the court, unlike the federal court, ignored the GAO. The GAO is the federal expert in interpretation of the GAO.
Mr. Nathan, I'm sorry, I'm running out of time.
Yep.
I think the Heller ruling was wrong.
I think so, too.
the court got it wrong.
I agree
but I
with
don't
you.
get to ignore it. I don't get to dismiss it.
But there's a
I don't get to advise the City Council that they can afford to do so.
There is a very substantial difference, Mr. Connolly, between the U.S. Supreme Court, which issued the Eller opinion, and one trial judge of the Superior Court of the District of Columbia, which will have no binding effect on any other court that considers this
Thank you. It's my time, sir. On January 30th, GAO opined the BAA was invalid.
Right.
But its opinion did not have the force of law. You don't have the force of law. On May 19, 2014, the U.S. District Court of the District of Columbia held that the BAA was invalid, agreeing with GAO. On May 27th, the U.S. Court of Appeals for the District of Columbia vacated that ruling and ordered that the case be remanded to Superior Court. Hardly some rogue court action here, Mr. Nathan. You're taking that out of context. It was in response to an appellate court without comment sending it back.
I didn't say there was any rogue court involved.
And without explanation. On March 18th, the day after the holiest day of the year, St. Patrick's Day, the Superior Court upheld the validity of the BAA.
It did.
Court ruled that the HRA only preserved the then-existing 1973 budget process. It did not prohibit the district from changing the local budget process in the future, confirming Mr. Nutter's legal opinion. Now, the fact that you think that court got it dead wrong is fascinating. You and I can have opinions about court rulings. That isn't how it works. He is sworn to uphold the law, Mr. Mendelson, and he's trying to do that, and he has an opinion. And I think that opinion is his protection against the Anti-Deficiency Act and against any charge that he's clearly thumbing his nose at Congress. And until and unless that opinion is changed or we take action, that's the law of the land, Mr. Nathan.
It's not the law of the land.
Well, it's a ruling he has to rely on.
District of Columbia.
No,
it is a decision of one trial court.
I'm sorry, sir. You're the one cherry picking. You're choosing a process you like versus a process you don't like. That's not what an elected official has to do. He doesn't get to do that. He has to rely on the court, the cognizant court of jurisdiction that has made a ruling. And until that ruling is overturned, or until we pass a law or take an action, he's perfectly in his right to proceed. My time is up. I thank the chair.
I thank the gentleman for his passionate plea, and I will recognize the gentleman from Wisconsin, Mr. Grothman, for 5 minutes.
We'll try to clean up a little here with Mr. Nathan. Thanks for coming on over. Why did the court remand the budget autonomy case, though?
Well, because the lawyers for Mayor Bowser, 3 months after she took office, went to the Court of Appeals. It was after it had been argued in the Court of Appeals. There was a transcript. There is a transcript. I urge the court, the panel to look at that transcript. Not a single one of the 3 federal appellate judges that heard the argument raised a question about the validity of Judge Sullivan's opinion, of the accuracy that which agreed with GAO, that this was invalid. But the mayor said that, unlike the previous mayor, and of course she was on the city council when it passed this law, she said she agreed with the law and therefore the matter was moot because now the mayor and the city council were in agreement. And the Court of Appeals said, okay, it's moot. The mayor's lawyer said, if you remand it to the Superior Court where this case started, we will seek dismissal of the action because it should be dismissed because it's moot and because as to the CFO, the matter is not ripe. And then, so that's what the Court of Appeals did. They vacated, they remanded, but when it got back to the Superior Court, those same lawyers said, well, we think it's urgent that this be decided now. We asked the Superior Court to decide it. And the Superior Court did not hold a hearing, as both the Federal District Court and the Court of Appeals did, but based on the pleadings and the memoranda that were filed, the court issued its decision. With respect to Mr. Connolly and the statement that about the Anti-Deficiency Act, what the Superior Court said essentially was that the statute, the Anti-Deficiency Act, doesn't say that the appropriation or fund has to come from Congress. And there is a fund here that the district has, and therefore this doesn't violate the Anti-Deficiency Act. In my view, as I said in my testimony, that interpretation is inconsistent with 100 years of federal jurisprudence that the Anti-Deficiency Act means that the appropriation or fund has to come from Congress. It says that all federal agencies, including expressly the District of Columbia, has to comply with congressional appropriations or funds. And I point out, as I pointed out in the testimony, that whereas the federal judge Sullivan relied on the advice of the GAO, which is the expert in the Anti-Deficiency Act, the Superior Court judge ignored the advice of the GAO and the opinion that it had rendered on this subject. I think what's important here is to understand that this decision by the Superior Court is not binding even on another Superior Court judge, much less on the appellate court in the district, and certainly not on any federal district court judge or the Federal Court of Appeals. And my concern is that there could be, and there already is, other litigation. There's litigation in the federal court, and once this takes effect, there is likely to be other litigation. And when there is this other litigation, a judge is going to have a choice between considering the decision of Judge Sullivan, the federal district court judge, who gave this very serious consideration and wrote a very well-articulated opinion on it. And they'll have that, and they'll have the opinion by Judge Holman. And my belief is that a court in the future is likely to be more persuaded by Judge Sullivan's opinion than by Judge Holman's opinion.
How would you advise Mayor Gray on the Budget Autonomy Act?
Well, I issued an opinion to him, and he reflected that in the letter, which is part of the record, where he told the council that because of the dangers of violating both the Home Rule Act and the Anti-Deficiency Act and putting district employees in jeopardy, that he was not going to implement the Budget Autonomy Act. That's what led to the litigation that Mr. Mendelson filed on behalf of the council.
And finally, in your opinion, did Congress intend to delegate to the district autonomous budget authority?
No, I'm afraid that the Congress in 1973 passed the Home Rule Act and specifically precluded the district from amending the Home Rule Act to provide for budget autonomy. It made it clear in Section 303D that the amending procedure could not be used to enact any law which would violate Sections 601, 602, and 603. Those sections said we are specifically reserving authority in the Congress, and we're putting limits on what the council can do. And among the other things that they said was you can't violate the Anti-Deficiency Act, you can't change the way the budget is operated now, both by the Congress, the President, OMB, and the practices and policies that had existed for the previous 100 years. And of course, when we looked at it, we had hoped to find the Budget Autonomy Act valid. But when we looked at it, we saw that the language of the statute, the legislative history, and the practice for 40 years after the Home Rule Act would not permit it. In addition to the fact that during the 40 years after Home Rule, that the budget was submitted as required by the Home Rule Act to the President and then to the Congress. Over that 40 years, every representative of the district, with the concurrence of the council, asked for legislation from the Congress to have budget autonomy. If those people who, including those like Walter Fauntleroy, who was there when the Home Rule Act was passed, if they believed that the district had that authority unilaterally to change it immediately after the passage of the law, there would have been no need to ask the Congress to pass legislation. I think that those proposals, which in my opinion were valid and should have been enacted by the Congress and can still be enacted by the Congress and should be, but the fact that they asked Congress to do it is a pretty good recognition that they understood that the D.C. government on its own could not do this.
Thanks much. I think I used up all my time.
I thank the gentleman from Wisconsin. The chair recognizes the gentlewoman from the District of Columbia, Ms. Eleanor Holmes Norton, for 5 minutes.
Thank you, Mr. Chairman. I regret that Mr. Nathan had to relitigate Superior Court decision. He's a member of the bar, so am I. Whatever is the final decision that is not appealed is the final decision until appealed. And so if you are Mr. Mendelson or the City Council and you have a court order from the Superior Court, it seems to me at the very least we ought to agree that Mr. Mendelson and the Council are protected given the final order of any court in the United States at this point. And we shouldn't get into nitpicking about whether you agree or I agree, because in fact, reasonable lawyers can and have shown, even at this table, that they can disagree on the validity of the Local Budget Autonomy Act approved in 2013. So I want to apologize to people who've come to this hearing expected to hear profound principled reasons why, since the birth of the nation, the district should have had budget autonomy over its own local budget, because I'm now compelled, for the record, to, in fact, engage in some statutory construction and to ask the witnesses about their views. Mr. Puey, you helped draft the Home Rule Act, and of course, that act establishes principles, or procedures at least, for the city to amend the charter. Charter can be amended. There are certain procedures. And for Congress to disapprove of a charter amendment during a review. Now, assuming, please accept my assumptions for purposes of this question, that the Local Budget Autonomy Act, the one that was recently passed, was not otherwise prohibited by the Home Rule Act, did the District of Columbia follow the procedures for passing and transmitting a charter amendment to the Congress for a review period?
Ms. Norton, I did not follow that procedure, so I'm not in a position to respond to your question.
I can answer it. You're correct, Congresswoman Norton. The procedures were followed.
Thank you, Mr. Nathan. Mr. Netter, here we really get into parsing legislation, but that's what's necessary here, I believe. I'm looking first at 603A of the Home Rule Act, which apparently everyone agrees the district may not amend. And it provides, and I'm quoting, "Nothing in this act shall be construed as making any change of existing law." Existing law, it says. Operative words as far as I'm concerned. And of course, it's referring to the budget. When the Home Rule Act was passed in 1973, existing law required Congress to approve the budget. Why then doesn't 603A prevent the district from enacting the Local Budget Autonomy Act?
It doesn't, Congresswoman Norton, and I think it's important to recognize also how Section 603A came to be. There was another proposed bill from Congressman Nelson that had a provision that became 603A, but it was worded differently. It said, "Notwithstanding any other provision of law, unless specifically authorized or directed by the Congress, there shall be no change made in existing laws."
No change whatsoever.
Right. Unless Congress affirmatively made a change. And that was revised in Section 603A to say that this act, the Home Rule Act of 1973, was not making any change. And that's why Section 603A doesn't limit the future authority.
It's very important what you just said, because the bill was a compromise bill. So we have right there two different versions and then the final version. Mr. Netter, all agree as well that Section 602A3 of the Home Rule Act may not be amended by the district. Now, this is a provision that prohibits the district from passing laws that concern, and here are the operative words I'm interested in, the functions or property of the United States. Now, the Home Rule Act, as passed in 1973, provided that the President shall transmit the district's budget to the Congress for approval. The Local Budget Act removes the President and the Congress from the budget process. That's its point. Please explain whether the Budget Autonomy Act violates the provision 6023A3, I'm sorry.
It doesn't, Congresswoman Norton. And there is a line of binding precedents from the D.C. Court of Appeals that dates back to 1982 with a case called District of Columbia versus Greater Washington Central Labor Council. And that line of cases explains that in Section 602A3, Congress was limiting the district's authority to exercise Congress's role as the national government, but was not limiting the district's role to exercise functions that Congress might otherwise exercise as the local government. So a series of cases have rejected the theory that 602A3 limits which actors are discharging those obligations. It doesn't matter if an obligation is moved from a federal official to a local official. The question is whether the underlying act would be pursued under Congress's national legislative authority or its Article I, Section 8 authority to legislate as the local legislature for the district. There's no argument that I can contemplate through which the district would be allowed to raise taxes under its local legislative authority, but could not spend that money under its local legislative authority.
Thank you very much, Mr. Chairman. I've exceeded my time. Do you have questions?
Yes. I mean, I want to be generous if
Right.
if the
I'd appreciate it.
If you have one follow-up question.
I do have it. What? It's not a follow-up question. My staff reminds me it's not a follow-up question. It's a question to the GAO.
Okay. All right. Well, why don't we do a very brief second round, and that way I'll be courteous to the gentlewoman, as any good member from North Carolina should.
Any good Southern gentleman.
Yeah. All right. Well, I didn't want to go there, but we'll. Mr. Netter, so do you concur with Ms. Holmes Norton's premise that 602 and 603 and 601 are unamendable?
I do agree with that, yes.
All right. So your premise under the Budget Autonomy Act is that you amended what?
Section 446 of the Charter was what was amended by the Budget Autonomy Act. And I think it's important to note that if it were true that Section 603A says that the Home Rule Act.
Yeah, I don't want to relitigate it. I'm just saying, for the record, you're saying that 601, 602, and 603 are unamendable.
They're unamendable, they remain in force, and they are being honored by the Budget Autonomy Act.
That's all I want to know, because I think our interpretation thereof, and my reading of it and your reading and the interpretation are vastly different based on the context. And so it's real interesting because you talked about this context that you went back. At what point or how many different documents did you ignore that talked about the appropriation authority wanting to be retained in Congress? How many different pieces of evidence did you ignore?
We didn't ignore a single piece of evidence.
How many of those did you leave out of your argument?
Oh, none of them at all. And I can tell you that it's entirely
Mr. Netter, you're under oath because
I am, yes.
Because I've looked at your argument, and there are a whole lot of information out there that seems to not have been included in your argument.
Oh, yeah, I disagree with that. You know, certainly our position is that Congress made a compromise.
So your testimony here today is that you found no substantial reason to believe that it was the intent of Congress to keep the appropriations process uniquely with Congress. That's your sworn testimony.
That's not how I would state it. I think this is an important distinction.
Well, that's my question. Is that your sworn testimony? No?
No. My sworn testimony is that Congress in 1973 was leaving the budget process in place. But in doing so, Congress did not create any impediments to the district proposing
Mr. Nathan, would you agree with that?
I do not agree with it, and it violates common sense. This law would not have passed but for Congress retaining the power of appropriations and the budget control and not having the district have budget autonomy. If those people who voted for that and insisted on that believed that the moment that the ink was dry on the President's signature, that the Council could change that, they never would have voted for this in the first place. And that's obvious by the 40 years of practice in the district and the repeated efforts by representatives, quite appropriately, to get Congress to grant budget autonomy. If they had that power, and that's what Congress thought in passing the law, they would never have sought the authority of Congress. They would have just gone to the Council.
So Mr. Netter, how do you reconcile that? How do you reconcile the gentlewoman to my right has asked for budget autonomy for Congress to act on budget autonomy for the district. Other members have asked that. Why would they be asking that if the district had the ability all along? How do you reconcile those two?
Well, I disagree that the district had the authority all along because of the Chadha problem that we discussed earlier, which is to say that in 1973, both chambers of Congress needed to affirmatively approve an amendment. So this issue only arose after Congress changed the process in the 1980s. And the reason—
So why is she's asked me for it since that particular— why would she have done that if they had the right to do it all? Is it just all of a sudden they found this right that they've been ignoring for 40 years?
Well, it's true that there was not a single amendment to the charter from 1983 to 2000.
That defies common sense. I mean, it just defies, and Mr. Netter, with all due respect, it defies common sense. So let me finish with this, and I'll
Mr. Chairman?
Hold on just one second. Mr. Nathan, are you aware of any federal actions that are taking place as it relates currently to the Budget Autonomy Act? Is there any litigation that is pending?
There is a lawsuit in federal court. It's actually before Judge Sullivan, asking to invalidate the Budget Autonomy Act. There is a very substantial question in that litigation whether the plaintiff has standing to raise this claim, and that has not yet been decided. But my concern, and I've explained it to Mr. Mendelson and the Council before, is that if this takes effect and monies are spent without congressional appropriation, those who are adversely affected by such expenditures will have standing to challenge the statute. And if they do, and if they bring it in any court they bring it in, but certainly if they bring it in federal court, there will be no effect of the Superior Court decision, and that judge will decide this matter afresh and will have the opinion of Judge Sullivan, it may in fact be assigned to Judge Sullivan, to render a decision on that, and that is why the actions of the district would be in jeopardy.
The chair recognizes the gentlewoman, Ms. Eleanor Holmes Norton, for another 5 minutes.
Thank you, Mr. Chairman. I think Mr. Mendelson wanted to comment on, and I know you didn't mean to cut him off, but your time had expired, so I'd like to give him some of my time to say why didn't, Mr. Nathan said you should have raised it from the get-go. How come you're raising it now and prior councils haven't raised it?
Thank you, Congresswoman. Let me try to struggle with this briefly. From time to time, particularly in the area of, I'll say, civil rights and voting rights, there are new theories that emerge. There were some advocates who came to me in 2012, and they said, we think actually that the Council has the authority to amend the Home Rule Act in this area. I was rather dubious at first, but this was a legal theory that had not been realized or argued or advanced prior to that. And this happens all the time if you look over the history of this country and the way arguments evolve in different issues, particularly issues involving civil rights or voting rights. So it was a new theory. We argued we argued it, and ultimately we won in court. The other thing I wanted to say is that a piece that I think is missing, and I say this from a lay perspective, I'm not an attorney, I'm somewhat familiar with the legal arguments and the minutiae of the legal arguments, but much of the debate here has been stuck in 1973. And in 1973, because of the compromise, it was clear that it was the intent of the majority of the members of Congress that the district would not be able to adopt its own budget. But Congress also adopted a Home Rule Act that had an amendment process. And that amendment process in 1973 was pretty locked tight. So if you were a Southern Democrat who did not want the district to have budget autonomy, and that was where the compromise was, you could look at the amendment process that was included in the bill and be assured that it was going to be over his dead body that we would get budget autonomy. But that amendment process changed. It changed through some acts of Congress, and it changed through some acts of Congress. And so that what had been locked tight, requiring affirmative act by Congress, was now a different process, and it's because of those changes that we were able to advance this amendment to the Home Rule Act. We have amended the Home Rule Act in recent years in other ways. The elected Attorney General is an amendment that initiated from the Council and went through the congressional review process, not an affirmative process by the Congress, but a passive review, and that was an amendment to the Home Rule Act. We believe, and Mr. Netter's better able than I am to articulate this, that the changes in the amendment process subsequent to 1973 are what allowed us to amend the Home Rule Act with regard to our passing legislation, which is the budget.
Mr. Mendelson, I'm very glad you made that argument. It is so clear. You barely got home rule by the skin of your teeth. Now you start out amending the darn thing. I have been waiting for somebody here to cite the amendments, the charter amendments that have in fact passed then. And the reason people are stuck in 1973, of course, is they're stuck in a period where, of course, our city got home rule in the first place in a Democratic Congress with profound racial overtones, with people who didn't want us to have it, because at that time, the majority of those who lived in the District of Columbia were African Americans, so they're going to start off by challenging the Home Rule Act. Give me a break. Let me indicate the best argument I can make, Mr. Nathan, for not immediately challenging or even in some of the ensuing years is when the 14th Amendment of the United States was applied to women. It was not until the 1970s, not for a moment, do I believe that women were not, in fact, subject to the 14th Amendment that provides that they are indeed fully equal when it comes to state action, until the 1970s when Ruth Bader Ginsburg argued that when she was a counsel for the ACLU. So I don't think you ever ask, what's wrong with you people? If you thought you were entitled to something all along, why didn't you just do it then? Look, I want to ask Ms. Emanuele Perez about her view, because she has said that the Budget Autonomy Act violates the Anti-Deficiency Act, and I've indicated I thought Mr. Mendelson was entirely within his right with the only outstanding court decision protecting the district. And I don't think she said otherwise, but she certainly has said that the budget autonomy, that it violates not only the Federal Anti-Deficiency Act, but the Budget and Accounting Act, which apply both to the District of Columbia and, of course, to the federal government. Now, I like Mr. Netter's view. I'd just like to say what you have said, that you have said that the Anti-Deficiency Act and the Budget and Accounting Act were not violated. So, Ms. Netter, can I ask you, does the Anti-Deficiency Act specify which, let us say, whether, I'd just like to get this out, this is important to clarify, and especially since it's a GAO, whether Congress or the district must authorize the obligation or expenditure of district local funds. Does it expressly say which one, or does it mention either one?
The gentlewoman's time has expired, so you can both very briefly, they have called votes, respond to that.
Yes, the Anti-Deficiency Act refers to an appropriation. When you look at the longstanding history of that act, it's always been applied to congressional appropriations.
But it doesn't say so, does it?
It doesn't say congressional appropriation. It's enacted by Congress, and it's referring to federal officials as well as district officials who have always relied on federal appropriations by Congress.
It does not say expressly which of those bodies, the district or the Congress. That's only when you go into statutory authority, you're looking first to see what is said. Then you go to see what was meant.
Yes, it does not say an appropriation enacted by Congress, but that is how it's always been interpreted.
I appreciate
because it comes out of Congress, and
that's what I wanted to hear. Thank you.
Mr. Netter, 30 seconds.
I appreciate it. Let me read into the record what the statute says. It says that an expenditure or obligation exceeding an amount available in an appropriation or fund for the expenditure or obligation. The District of Columbia government possesses the District of Columbia General Fund under Section 450 of the Home Rule Act. That money does not pass through the Treasury and is not subject to Congress's constitutional power of the purse. The only question is whether the amount was made available, and that becomes a circular question. If the Home Rule Act is otherwise valid, as the Superior Court has found that it is, then all of the requirements of the Anti-Deficiency Act have been satisfied.
All right. I want to thank all the witnesses. Mr. Dupuy, do you agree with Mr. Nathan's characterization of the intent of Congress? Yes or no?
Yes.
Okay. Mr. Mendelson, in your response, it was clear that you said the original intent of Congress was retain control of the appropriations process in your previous answer. Is that correct?
Yes. Yes, in 1970.
All right. So I want to thank all of you for this illuminating hearing, and obviously it is one that will continue to go on as we address this issue. I also want to thank the audience, because I know that this is something of great passion and great concern to so many, and